I tend to spend my time where it counts the most. Sometimes when family needs me fix something or make something happen, then I put everything down and do that. And oftentimes it involves picking up new skills.
Skill, baby, skill.
Learning how to diagnose electrical issue in the house or kind of like fix something that broke, right? So if I didn't install it, I need to find out what's wrong and diagnose it. So these kind of DIY projects, sometimes around the house or, to be there for my family for various things is where I believe makes the most difference. The difference actually between a letter from a law firm and a mediation request is really that the law firm will tell you what their client is asking for. Whereas a mediation request doesn't go so far, it just essentially invites you to conversation with a mediator. And I suppose you could say that the letter from a law firm could be more intimidating because it's typically phrased or worded in the form of a demand, such as a letter of demand or a cease and desist, which tends to carry perhaps language that is a little heavy-handed, but that's just what lawyers do. In essence, they are trained to meet their clients' demands or interests. Whereas for mediation requests, you find that the parties go into a different mode. And whilst the parties might know what the situation they find themselves in, you find that the mediation request does not necessarily allow the parties to know what the other party is specifically looking for in the given situation. So I would say that actually it's good to have both. A strongly worded letter of demand does not necessarily need to be met by an equally strongly worded defense or strongly worded response. You can actually parry the response so that you acknowledge the dispute and you suggest that the parties go for mediation. And oftentimes, if parties know that their case is not 100 or 0, they would view the request favorably. Just because you make request to mediate is not admission of any weakness on the part of your case. In fact, is that if you are on the receiving end of a letter of demand or a strongly worded letter, or you get your lawyer to draft brief response to deflect or to, perhaps acknowledge some of these things, but, to gently deny that the sting of these accusations, and thereafter to suggest maybe on a without prejudice basis to go for mediation so that the parties are able to problem solve and to resolve their differences amicably. And I think that's the new way of doing things, because prior to the developments in relation to mediation over the last 8-10 years, you find that a writ of summons was really the only way to resolve a matter which is before the courts. Whereas now, I find that more and more parties are open to chat or a discussion, and sometimes if they find that it's difficult to have that chat or discussion directly, they welcome having a mediator in the room so that the discussions are moderated and the comments are filtered, and at least that the parties can see that there is a mediator who can guide and facilitate the conversation, which is very helpful, because you find that when there are two parties in the room who are very unhappy with each other, there is a very, very high likelihood that one of them will walk out of the room because there's nobody who is in charge or nobody who is kind of overseeing the carriage of the conversation with the intention or with the goal of trying to resolve the differences.